about some of those today. So it's easy to get emotionally caught up in the drama of stand your ground. Who gets it, who can't claim it, the lives that are damaged, the families that are devastated. But as lawyers, we're called to do more than be upset about it. At some point, we have to take advantage of the education and training that we've been fortunate enough to receive and strike a blow for justice. And at some point, it doesn't matter so much who's on the bench. At some point, the law is about right and wrong, justice and injustice. And that's why we're here today. I am pleased and proud to introduce somebody who has become almost like a family member to me, a son, if you will. I've known him now a very long time. He's a very committed young lawyer, educated in part with a Rainbow Push Coalition scholarship to go to Chicago. He's been practicing law now for several years and has taken on several difficult cases with great results and a lot of fortitude. I want you to help me welcome Robert Patillo, who will tell you about the lawsuit that we will file today to invalidate Georgia's stand your ground law. We hope that other states, we have state representatives here from other states around the South. We hope that they will attempt to repeal stand your ground in their states. We think that there is great consensus among law enforcement, among district attorneys, and others inside the system who know that this, no matter how popular it may be, it is not good public policy, and it's not leading us in a good direction in terms of how we handle criminal justice. I also want to thank Richard Holmes, who is here. He chairs, is Richard up here? Richard chairs our Criminal Justice Committee for Rainbow Push. But without further comment, let me introduce you to Mr. Robert Patillo.
Good morning, or to say good afternoon. We've come here today to challenge the state of Georgia's stand your ground law. As many of you know, the stand your ground law became national attention with the death of Trayvon Martin in the state of Florida. However, this law affects more than simply the state of Florida. It impacts people in 22 states nationwide, especially here in Georgia. We're joined here today by the families of James Christopher Johnson III and also the family of Herman Smith III. Both of their sons have been victims of stand your ground in different ways. Because of this, they have agreed to be plaintiffs in our suit seeking to invalidate the state stand your ground statute. We believe that the statute is unconstitutional, based simply on a violation of equal protection and a violation of due process. In the law, the laws have to be precise. Laws have to apply evenly to all individuals regardless of race, sex, creed, culture, age, and any other classification. There's not one speed limit for young African American males and a different speed limit for older Caucasian individuals. There's one standard that has to be applied. This is why justice is supposed to be blind. But as we've seen with stand your ground, and as is exemplified in this case, laws are applied differently to different individuals. And because of that, we believe the law has violated the Equal Protection Clause of the 14th Amendment of the United States Constitution. Additionally, citizens have a due process right to understand what is legal and what is illegal. So if the law states that if you have a reasonable belief that you're under threat, that you can use deadly force to defend yourself, that has to apply to everyone in all cases, in all situations, not to some at some times. We believe that the arbitrary and capricious nature of the invokement of the stand your ground law and the way that the law has been administered has resulted in unjust and unfair results here in the state of Georgia. So today we're filing this lawsuit in the United States District Court here in Atlanta, Georgia, to try to have the law overturned. And with that, we'll open the floor to any questions. So just as a way to give background on the cases in the suit, we're joined here by the mother of Mr. Herman Smith. Herman Smith was a young 21-year-old in Carrollton, Georgia, who attended a birthday party. An individual at the party walked in with a loaded handgun threatening to shoot individuals at the party. He looked at Mr. Smith, walked towards Mr. Smith, appeared to be drawing his weapon, at which point Mr. Smith shot that individual, killing him, protecting the life of both himself and other individuals at the party. At trial, Mr. Smith was convicted of felony murder. The jury held that he did not have a reasonable fear for his life, despite the pictures, the witness statements, despite all the evidence showing that there was an individual with a loaded gun coming towards him. In his case, stand your ground did not apply. We're also joined by the family of Mr. Christopher Johnson. Christopher Johnson's a young man in Coweta County, Georgia, in Noonan, who attended a restaurant with his girlfriend, who happened to be a Caucasian female. An individual by the name of Adam Lee Edmondson walked into the establishment, began talking to Mr. Johnson's girlfriend. He told him to leave. The next day, same bar, same parties, same thing happens. Mr. Edmondson again harasses Mr. Johnson's girlfriend. He requests that he leaves. An altercation takes place, is broken up. All the parties disperse. Several minutes later, Mr. Edmondson comes back with a loaded handgun, points it into the chest of Mr. Johnson, pulls the trigger, killing him. At trial, Mr. Edmondson was acquitted on stand your ground. It was determined that he had a reasonable fear for his life, even though he was armed and the other person was not armed. In Georgia, stand your ground only applies to certain people at certain times. And there's no way to determine who it applies to until after the act has taken place. We believe that for these reasons and for additional reasons which are laid out in the complaint, that the state of Georgia has to overturn this law. And as we've seen in both the United States Congress and in the State House, it's very difficult to get things done legislatively. Because of the arbitrary nature of the enactment of this law, because of the deadly consequences of this law, we believe that only the strictest and most well-written laws should justify it. And that's the reason that we're joined by these families here today, by their attorneys, Mr. Harry Daniels, Vicente de la Cruz, Chris Stewart, who are here representing the families. They've agreed to join with us in this lawsuit to try to invalidate this. And with that, I would also like to introduce some of our dignitaries. We have State Senator Gail Davenport. We have Helen Butler for the Georgia Coalition of the People's Agenda. We have Fred Favors here also. And with that, I think we're ready to open the floor for questions from the media.
To my knowledge, there was a similar lawsuit which was dismissed. What makes you think this one will be successful?
The difference was that's a suit we filed really 2 years ago on the same issue. That was a general suit without specific plaintiffs. So the question in that case was standing. In this case, there is no question of standing. We have aggrieved parties who have served an actual cognizable injury. That's the primary difference between that suit and the previous suit.
Is it your goal just to do away with the law altogether, or would you like, if you could do it legislatively, where you had specific standards that you had to meet, would something like that satisfy you?
Well, in this case, what I anticipate what happened is if the law is overturned, the so-called Senate Bill 396 or the OCGA 1623-1 24.1, the stand your ground provision, which what that did was abrogate the previous common law on self-defense. So if the stand your ground law is overturned, we will return to the previous common law on self-defense until the legislative solution can be put in place to amend and replace the current law.
So what specifically would you like for the law to say or allow?
Well, right now the text of the law simply states that if an individual has a reasonable belief that another individual will commit some felony or some violent act against them or their property or someone else's property or their house, they use deadly force to defend themselves. We believe that the law has to be more specific than that. Simply putting a reasonable belief standard on issues of life and death is far too loose of a belief. We believe that if anything, the law should be concrete, that should lay out certain criteria where the law applies. It should lay out certain circumstances and situations where the law applies. And it should also have portions of the legislative language that lays out exactly how it's